Good afternoon, everybody. I'm Kate Turner. I'm a director of Pinsent Mason's energy practice. It's a pleasure to be here talking to you this afternoon. I just wanted to put a legal context from, I suppose, more higher level around people embarking upon decentralised energy projects. The role of decentralised energy in the energy mix, as we see it, is growing in attraction as it provides businesses with lower cost and more secure energy at more stable prices. Added to this, a growing number of decentralised technologies such as AD, biomass, solar, wind, for example, carry zero and near zero emissions, which obviously make them attractive in terms of climate targets. The public sector is obviously well placed, given its access to housing stock and cheaper capital, and through heat mapping and energy planning, to identify opportunities where energy can be supplied from decentralised, renewable or low carbon generation systems, and for co-locating potential heat customers and suppliers to further aid the development of low carbon heat infrastructure. So for the purpose of today, I wanted to look more closely at some of the project considerations involved in these larger scale schemes, and particularly looking at heat networks, as these schemes can offer an affordable way of achieving low carbon energy supply in populated areas. So the first thing I wanted to tackle was the term ESCO. This term is often used, but it's not always very clear what is meant by it. It's an energy service company. The use of the word company is misleading in itself, as it need not be a company incorporated under the Companies Act. For example, it could be a trust or unincorporated vehicle. Where projects contract with an ESCO to implement or improve the efficiency of energy services, this is often referred to as energy performance contracting, and you've also heard that this afternoon in terms of what the NHS has been doing. So for those who aren't already familiar with what this term means, energy performance contracts are different from usual contracts for the provision of energy services, as an EPC energy performance contract typically includes an incentive for the contractor, which normally means that the contractor is not paid unless the savings, financial or otherwise, that have been forecast by the energy improvements that they're putting forward have been realised. If those savings aren't realised, the contractor may have to guarantee and underwrite the unrealised savings, or, for example, the emissions reductions. The term ESCO is also sometimes used to refer to an entity set up by public sector organisations with or without private sector participation for the purpose of delivering a combination of measures related to energy efficiency, energy savings, or sustainable energy solutions. In the context of larger district heating projects that are being developed, where ownership, funding and management are not all provided by the same party, it's commonplace to set up this type of company as a new special purpose vehicle. Just as with any decision as to what sort of project to pursue, the particular ESCO and project structure selected will very much depend on the project-specific matters, including cost and funding, attitude of the contracting authority to risk, the degree of knowledge and experience within the contracting authority on energy matters, and the range of measures being contemplated, along with the number of stakeholders involved. It's also worth mentioning that some projects may be able to proceed without setting up an ESCO at all, such as where an authority has allocated funds to a project that it is able to operate in-house. Although it can often be the case that those projects run the risk of losing additional impetus and focused management that are usually delivered by setting up a separately accountable special purpose vehicle. For the purpose of the next few slides, I'll cover some of the legal considerations where the ESCO is being set up to provide district heating, although some of the considerations will apply equally to ESCOs being set up for other types of projects or a combination of measures. So on this slide, you have some of the key objectives that a public authority may consider when considering embarking on a district heating project. The key thing to say here is when you're identifying these, you have to be clear about your objectives before embarking on any project, as this will impact on the most appropriate delivery structure that might be adopted. I won't go through these in detail because each organisation would have their own view on this. So, legal considerations. Starting at the top, ownership and key stakeholders. How the delivery vehicle for the ESCO is set up will depend on a combination of factors. Where the ESCO's function is focused on matters of social, economic and environmental well-being, and where commercial considerations of making a profit are perhaps secondary, it is appropriate for the public sector in those sorts of cases to own the ESCO. However, depending on factors that we've already talked about, appetite to risk, control, finance and exit strategy, there are a variety of models for ESCOs that should be considered, ranging from wholly public sector owned, public-private partnerships, stakeholder owned, to wholly owned private sector companies contracting back with the public sector entity. It will also be important to consider whether there should be any tenant or other community participation in the delivery of a specific heating project. A cooperative type model may be considered, as this would ensure that the ESCO is owned and governed by its members with the aim of meeting common social, economic and environmental needs. Where there is more than one shareholder in an ESCO, it will be important to separate commercial objectives from conflicting policy or political ambition. Otherwise, this could easily derail the decision-making process and make the ESCO or its projects unbankable. Turning now to governance, as we've already discussed, it's common to set up a separate SPV to ensure separate accountability and risk management, limited liability and retain flexibility for funding and future exit. The mechanics of setting up an energy service company are generally fairly procedural from a legal perspective, but it will be important to consider at the outset the governance arrangements in terms of the memorandum and articles of association of the proposed company, who the directors will be, to ensure that key stakeholders' interests are properly represented and that the appropriate expertise is available for the delivery of the scheme. With respect to interface issues, it will be essential to have a clear delineation of roles and responsibilities of parties set out in the project agreements. The approach taken to the structure of the documents will in part depend on the degree of risk the sponsor is prepared to accept, and the complexity of the structure and contractual mix will in part depend on the number of interfaces with other stakeholders or private sector companies. On heat sources and offtake, some heat sources only become financially viable when certain size thresholds are reached. Therefore, it will be important to ensure that the energy centre is designed accordingly. With respect to identifying anchor tenants to accept communal heat and charging, it will be important to address any uncertainty regarding longevity and reliability of heat demand, or the ability to link other heat loads. Customers will often want or need to continue to be able to install their own heating, but this need will be at their own cost generally, and the aim of any scheme should be to supply heat that is cheaper than other sources, so that there is no incentive for a customer to switch back to an alternative source. Responsibility for metering and billing will need to be addressed, and the ESCO will need to ensure that its companies are capable of paying their heat bills, otherwise there may be significant exposure to bad debt. On funding, this should be considered at an early stage in the process. For example, how will the ESCO be funded? What are the sources of funding available? What are the conditions of any loans or terms of repayment, so that this can be reflected in the chosen project structure? The challenge is often one of identifying the best solution at the best price. Funding will also need to be considered where there may be a split of ownership or responsibility between the energy centre and the pipeline network, as the financial viability of both may be interdependent. For example, if ownership and control of the energy centre and the pipeline network is split, it is possible that the energy centre may become uneconomic, but the pipeline network used for distribution of the heat may not. Therefore, the contractual arrangements need to be put in place to ensure that overall viability of the heating scheme remains financially viable for all parties responsible for all parts of the scheme. Where external finance is used, the providers of finance will generally need to see an ESCO project structure that is capable of securing cash flows and which provide for efficient operational arrangements and the necessary degree of accountability and control to the funders. I'm sure Gregor will be able to comment further on this aspect. Skipping through then, pricing, transparency and surplus income. Where a not-for-profit model is envisaged, consideration will need to be given as to what happens to surplus income in terms of reinvestment in further development of heating projects, management of replacement costs of the scheme in the future, and how decisions are taken as to the priority of new schemes. Future-proofing, it will be important to consider a project structure can stand the test of time and be suitable and adaptable for future needs. The question often arises as to whether or not it's possible to oversize an energy centre or pipe network to allow for future connections. This will need to be considered in terms of whether oversizing satisfies the requirements of best value, where there's local authority involvement, or value for money, where other public bodies are involved. On exit strategy, it will be important for any sponsor to consider an appropriate exit strategy to ensure that it's not locked in, either through the funding mechanism or inadequate contractual provisions to allow for a smooth exit. I've not covered property or planning issues, or importantly, procurement and state aid, as these can be topics of themselves, but needless to say, early advice on these areas will be essential to any public sector district heating project. I'll jump through these. We've probably covered most of the points in one way or another that come up in terms of key project considerations. And this is generally speaking what a very basic ESCO structure could look like in terms of funding and the contractual makeup of the project. Moving on to asset structuring, just a brief word here. This slide shows basic project structure where the energy centre and the pipe network are owned separately. This raises several issues that should be addressed by those looking at the legal structures for decentralised energy schemes, such as the fact that there is no legal or regulatory framework to enable separate heat networks to be connected together, so reaching commercial agreement on this will be absolutely key. The cost of physical connection and any risks attached to it, potential use of system charges to be levied by a heat network owner, the rights of heat customers to switch suppliers where alternative sources of heat are available, common engineering standards to ensure connection is physically possible, cost transparency, and the linking of networks offers further possibility of more than one heat source being available to customers and the prospect of those heat sources competing. Therefore, there will be greater interface issues for a network operator to manage. In terms of delivery structures, you heard some mention of concession structures earlier. The contract structure that's most appropriate for a particular project will depend on the main contractual elements that are being looked at: the works, the services, the property rights. Concession structures are often associated with new developments where the sponsor can provide exclusivity or a demand guarantee, and in effect, the project risks are transferred away from the sponsor of the ESCO. In a DBO, design, build, operate structure, these are usually where demand is dominated by a limited number of customers, for example, council-owned buildings or social housing or shopping centres. The project sponsor would be responsible for the pricing of the heat and for the customer interface and would normally pay for and own the assets. The owner also takes the majority of the operational availability risk and may retain responsibility for new connections. One of the strengths of this approach is that it can make best use of the sponsor's access to lower cost fuel or lower cost capital, and also retains control over the prices of the energy to be sold to customers. Selection and negotiation of a DBO contract will be key to ensure service reliability and limiting the ability for O&M costs to creep upwards. However, the type of contract structure usually requires a greater degree of specification detail than a concession structure, as more of the risk remains with the sponsor. Probably running a bit out of time, but on risk mitigation, just lastly, pick out a couple of these I've probably mentioned in passing. Metering and billing. Accurate metering and billing is essential to minimise the quality of bad debts. And new connections will require complex negotiation, involve disruption to operations, and put performance standards at risk. Therefore, it is usual to include performance targets within the relevant contract, whether that's an ESCO master agreement, DBO, or O&M agreement. That's probably everything. Thank you very much.